Privy Council to decide Hadeeds' fate. Appeal court upholds stay of house arrest order. Businessman Dominic Hadeed, his wife Genevieve, and their formidable legal team were left disappointed last night after Chief Justice Rani Budusingh and two appellate judges granted a stay of a decision of three of their colleagues to order them released and placed under house arrest. The stay was sought by lawyers representing the TNT Police Service, TTPS, and the Office of the Attorney General, after appellate judges Peter Rajkumar, Meera Dean Armorer, and Joan Charles upheld the couple's appeal challenging a decision by High Court Judge Frank C. Prasad to refuse their interim release on Thursday. Delivering an oral decision after hearing lengthy submissions from state attorneys and the couple's lawyers at the Hall of Justice in Port of Spain last night, Budusingh and Justices Mark Mohammed and Ricky Rahim ruled that the balance of justice required the stay pending the final determination of an appeal before the United Kingdom-based Privy Council. Budusingh said the potential risk of the couple continuing an alleged plot to assassinate key government officials, if they are released under the supervision of the police, was greater than concerns raised over Hadeed's deteriorating health during his detention over the past 3 weeks. He suggested the medical concerns could be assuaged by state officials facilitating access to his specialist doctors while he remains under detention. Attorney Gerald Ramdeen, who represented the TTPS and AG's office, assured the court such access would be provided. "I undertake to make representations to the Attorney General and the Commissioner of Prisons to entertain any request that can assist with his health." Budusingh noted that the state had raised compelling grounds challenging the first panel's judgment and that an urgent appeal could be considered by the country's highest appellate court in the next 2 weeks. He noted that the panel he chaired did not seek to overturn their colleagues' ruling in favor of the Hadeeds or their denial of a request for a stay pending an application for leave to appeal to the Privy Council, which was granted later that night. He also pointed out that the decision on the stay was not based on an analysis of the merits of the couple's substantive lawsuit alleging they are being targeted by the government based on their ethnicity and a move to terminate their leases for parcels of state land. Concerns raised by the couple's legal team over the lack of evidential grounds relied on by Homeland Security Minister Roger Alexander to place them on preventive detention orders, PDOs, he said, were not relative for the stay. Attending the hearing from separate video conferencing rooms at the Golden Grove State Prison in Aruca, Hadeed and his wife appeared dejected upon hearing the outcome, as they were both seen with their heads bowed and in their hands. Presenting submissions in support of the stay, British King's Counsel Sir James Eadie raised concerns over the ability of the police to facilitate the couple's detention under supervision at their West Moorings home. "It is not difficult to communicate from the home without electronic devices if there is a will to do so," Eadie said, suggesting that 6 police officers would be required to secure the property, which has waterfront access and 2 jetties. He also claimed that Hadeed's need for specialist medical treatment for several illnesses and a genetic condition did not outweigh national security concerns. The solution is to ensure that he has proper access, not to release them. In his submissions, Douglas Mendez, SC, claimed the first appeal panel was correct in their ruling and their decision to refuse an interim stay. Mendez referred to evidence presented by one of Hadeed's doctors, who examined him before the hearing, and suggested he may be left wheelchair-bound if he does not receive treatment for his neurological condition. Mendez also took issue with particulars provided by Alexander in response to Hadeed's parallel legal challenge before the state of emergency, Review Tribunal. In an affidavit filed on Thursday, Alexander disclosed a report from the Strategic Services Agency, SSA, dealing with a call log from Genevieve's phone, which claimed she was communicating with 2 men considered persons of interest by local and foreign law enforcement agencies. Mendez provided an affidavit from one of the men, Michel Tallman Guard, Victor, who serves as the security guard and driver for the couple's 3 children. Victor claimed he made the calls as he was tasked with dropping one of the children's friends home and got a flat tire on the return journey. He pointed out that the other man, Oliver Alexander, no relation, is a retired energy worker who runs an NGO in Mayaro and would occasionally seek donations from the couple. Referring to Alexander's affidavit, Mendez noted that several senior judges had delivered speeches at the NGO's functions in the past. The slightest bit of investigation would have led him to realize that the SSA was providing him with information that takes him nowhere. "It is nonsense," Mendez said. maintaining the police had presented no evidence to even partially prove his clients were part of a murder conspiracy, as alleged. While the state claimed an appeal could be swiftly facilitated by the Privy Council, Mendes noted that its registrar previously said it would not commit to a date until fully apprised of the nature of the appeal. The couple and a 70-year-old relative, Star Sabga, were arrested last month and then placed on PDOs. Justice Siprasad granted them leave to pursue a lawsuit alleging breaches of their constitutional rights, but declined their release on the basis of previous cases, citing the need for deference to the executive on matters of national security. In overturning Justice Siprasad, the first panel found he failed to properly consider that the Homeland Security Minister provided insufficient grounds to warrant their detention under PDOs for the remainder of the SO, which ends in mid-September. A conspiracy to kill senior members of government requires particulars of that conspiracy in order to justify preventive detention. It is not sufficient to indicate that the first appellant, Hadeed, has the means to carry out such a conspiracy if the conspiracy itself has not been identified, the judges said, adding that having the means to carry out a conspiracy or plan is not sufficient grounds for a preventive detention order. The first panel also took issue with Alexander's reliance on intelligence reports from an unnamed national security agency in the PDOs. Vague assertions, therefore, of intelligence without explaining how that intelligence reflected the ongoing conspiracy and the development of plans arguably did not satisfy the statutory precondition for the exercise of the power to issue the PDOs, they said. Sufficient justification was required to demonstrate compliance with the statutory preconditions for the exercise of PDOs and to permit detained persons to at least know the reason for that extreme and draconian exercise of executive power. The panel also rejected claims that the couple had an alternate remedy by challenging their PDOs before the SO Review Tribunal, pointing out that the tribunal can only make recommendations, which are not binding on the minister. Noting that Alexander had rejected previous recommendations by the tribunal in relation to other detainees, the panel said, "The existence of the tribunal therefore does not constitute an adequately effective alternative remedy." The judges also took issue with Justice Siprasad's ruling that the couple could be financially compensated if eventually successful in their substantive legal challenge, finding there was a low risk of irreparable harm if they were released with strict conditions, as the police were free to continue their probe and charge them if they gathered sufficient evidence. In a brief interview after the second panel granted the stay last night, senior counsel Faris Al-Rawi summarized its effect on his clients. In effect, our clients have had a cake given to them that they can't eat. They still are the beneficiaries of a judgment in their favor, and that is that they should be released. He said he and his colleagues had always expected the Privy Council to consider the case and would immediately start working on the final appeal. So, we continue to work assiduously. The case has a number of ramifications to a number of people, but it also stands quite unique in its perspective because there are some very unique features of the case. We intend to spare no effort. We intend to push for the fruit that has been given and awarded. Al-Rawi also said he would be seeking the medical treatment which the state agreed to facilitate after it received the stay. He has not received 1 minute of required therapy, he said. Today, our medical evidence put before the court by an expert demonstrates that there's been significant deterioration, which could likely see our client end up in a wheelchair. There is no cure for what he is battling with, and that he spent his entire life fighting. Asked about his client's response to the latest development, Al-Rawi said, "I think that the whole world witnessed what happened there. My clients are strong people. They respect the law." The Hadeeds are also being represented by Gilbert Peterson, SC, Rishi Das, SC, Chase Paguz, and Carlin MacLeod. The AG's office is also being represented by Dayadai Harapal and ASP Ramdath Philip, the head of the TTPS's legal unit.